Are you ready? Is everybody ready?
She's ready for that.
We're just looking for the clicker, Judge.
To be able to click his.
Cycle through the slides.
The doors on below, and she did do something there.
Keyboard. Let's watch this in because I can just use the keyboard. No, I can't reach.
It was there, it disappeared. Let IT know. The clicker disappeared.
They should bring it.
Yes, they should bring it.
Yeah, we don't have one.
Oh, no.
If you want, you don't hide it.
Yeah, but I can't.
Yeah, you got this.
Yeah. I'm scared.
I'm not gonna be able to hear you.
You don't have a computer, but
But I mean,
I click share. Just doesn't call
grabbing someone from my safe lap, grab one. Okay, they're grabbing one. Okay, just a second.
It comes down, we'll plug it in.
So are you ready?
Your state is, ran to grab a clicker, Judge. It's on its way downstairs.
I'll get it.
Let's go ahead and begin with that clicker, and then when you get it, we'll start right off. Okay, so we can start with some sort of argument and the like. Let me call the case. 2024 CR 012097, Steve, this is Brad Chandler Simpson. Will the lawyers please state their names for the record?
Casey Sandoval for the state of Texas.
Stephen Gilmore, Brittany Durham, and Tanya Rivera for Mr. Brad Simpson.
And
Will
also-
Benzine for the state of Texas as well.
Okay, and sir, are you Brad Chandler Simpson?
Yes, sir.
Okay, we're here today because the defendant filed a motion to quash the indictment. I have that in front of me. I also have the state's response to defendant's motions to quash. And I have defendant's reply to state's response to the motion to quash the indictment. Okay, so to you, Counselor, you're the movement. Do you have any opening statement, or you just...
No opening statement, I mean, just the argument, Judge.
Okay, then, do you need the clicker to start your presentation?
I mean, I would like it, Judge. And one of the reasons that I think that the PowerPoint is helpful is because I kind of diagrammed what we were discussing earlier, which is this distinction between the result of conduct and the nature of conduct type offenses.
It's coming.
And so, one of the things, and in the concurrence, the opinion cited by Judge Clinton in Lugo, one of the things that Judge Clinton does is he comes up with this chart where he like helpfully subdivides what is actually alleged in the statute, right? And so part of the allegation has to be an act clearly dangerous to human life. And that act, that there's a causal nexus between the act alleged and the result. So it is still a result-oriented offense. It's the gravamen of the offense, as the state cited in its brief, is still the result. But we're not talking about the result with respect to the culpable mental state. What Lugo does, and what the other cases that I reference in my response, is they discuss nature of conduct versus result of conduct with respect to the culpable mental state. And what essentially they mean is that the culpable mental state for a nature of conduct offense could be, say, knowingly, or in the circumstances of conduct offense, it could be, say, recklessly. But because it's a result of conduct offense, the requisite mental state is the intent, and in this particular case, intent to cause SBI. Intentionally causing SBI is what the defendant has to have. SBI, serious bodily injury. That is what the, thank you so much, I'm very grateful. Perfect, yeah, goes forward. Two. Okay, and so because, let me see if this, there we go. And so here's Judge Clinton's chart. To my mind, kind of breaks it down in the simplest way. That intent to cause the serious bodily injury by committing the act, that is the nature of conduct. That's the nature of what the defendant is accused of doing, right? And then it results in the death of an individual. That is the result of the conduct that the defendant engaged in. Whether or not the defendant recklessly engaged in the conduct doesn't matter, because the state has to prove that he intentionally engaged in that conduct. And so in a result-oriented offense, the state must also prove that the appellant caused the result with the requisite criminal intent, which again I've said is intentionally in this particular case. To change it to a nature of conduct offense, to actually convert the characteristic of murder, would allow the state to allege that he may not have done it intentionally, but he could have done it knowingly. And that is what the courts of appeals and what the majority opinion in Lugo says they cannot do, which is ordinarily something that the state wants to do, because it would allow them to plead alternate mental states for committing the offense, which would give the jury, in a hypothetical case, different mental states by which they could convict a defendant. And so I'm not suggesting that they would be allowed to do that under this. I'm just suggesting that there is a nature of conduct element, and because there's a nature of conduct element, they got to tell me what it is. Now, looking at just paragraph B, I've kind of diagrammed it a little bit as well. So that, in this case, Brad Simpson committed an act clearly dangerous to human life. That is the nature of his conduct, committed with intent to cause SBI. That's what the indictment puts me on notice of. That caused the death. That's the causation element. That the result of the conduct, the act that occurred, the clearly dangerous act, and then your guess is as good as mine, because they just alleged that it's by manner and means unknown to the grand jury. That somehow this act that's clearly dangerous to human life is also, I don't know, unknown? And that's not noticed, Judge. But this discussion about result of conduct and nature of conduct, that's me responding to the state's brief. Ultimately, it doesn't matter for the purpose of determining whether or not I have notice. Notice is the issue, not the culpable mental state, and whether it's a result of conduct offense or nature of conduct offense is immaterial. What I'll point out is the penal code does not define what an act clearly dangerous to human life is. There's no definition from it, and because there's no statutory definition, we're not allowed to put a definition in the jury charge either. So the jury's not going to get to know what an act clearly dangerous to human life, which also means I don't get to prepare to defend against whatever act the state may be alleging. There could be a number of statutory defenses. There could be a defense that it never even occurred, or that there's an exception or excuse. But because the state hasn't alleged it, I don't get to prepare a defense to that particular act. And because it's undefined, the case law is very clear that if the Court of Criminal Appeals is State v. Barbanel, if the statutory language, in this case, an act clearly dangerous to human life, isn't completely descriptive, they have to plead it with greater particularity in order to provide me notice. Work there. And even in the state's own case, Zuniga, when a statute contains an undefined term, indeterminate or variable meaning, the state has to tell me what it means in the indictment to put me on notice. Zuniga is one of the leading cases that the state cites, and that their own case says they got to tell me what it means if there's no definition, and there is no definition. And ultimately, Judge, the pleading requirements for murder under 1902B1 are just fundamentally different from what they are in 1902B2, which is what paragraph B is. And in DePaul versus State, it tells you that for a 1902B2 case, the state must allege and prove that the accused committed an act clearly dangerous to human life. And in this particular case, they rejected the state's cases suggesting they don't have to allege a particular act and said that even though you don't have to tell them under 1902B1 murder what the act is, the cases that you're citing for that proposition, they don't apply to 1902B2. So you got to tell them what it is. In the brief, I referenced that this is potentially an issue of first impression. These are the cases that I could find where notice was raised in a 1902B murder, and each and every one of them alleged manner and means unknown plus something else. Not a single one of them alleged manner and means unknown and nothing else. The only case I found that did talk about it was a case out of Eastland that said nobody mentioned this in the trial court or on direct appeal, so we ain't going to touch it. The other thing that all of those cases have, that this does not, is the literal corpus delicti was satisfied. And I think that that's significant in terms of putting me on notice. Because in cases where literal corpus delicti is satisfied, I would have a medical examiner's report, which I don't have in this case. The state also alleges that they can give me notice by other means, and I'll cite there at State versus Rosenbaum out of the Court of Criminal Appeals. This is not in the brief. But the validity, whether or not an indictment gives me notice, isn't tested by the evidence that is adduced at trial. That's an argument for the sufficiency of the evidence on direct appeal. Whether the indictment gives me notice has nothing to do with what's contained in the discovery the state's obligated to give. That's all I got, Judge. For those reasons, I pray you'll grant the defendant's motion to quash paragraph B of the indictment.
Okay, State.
May I please support? Would you prefer that I stand, Judge? All right. Judge,
Move that mic a little bit closer to you.
Yes, ma'am.
Thank you.
turn it on.
Turn it on, move it closer to you. Thank you.
All right, Judge, I just want to start by saying the law doesn't reward people for disposing of the bodies of their murder victims. The case law is clear that the state does not have to prove how Mr. Simpson murdered Suzanne Simpson. What we do have to prove is that he intended to cause either her death or serious bodily injury, and that he did in fact cause her death. And I won't belabor that point because it's addressed fully in the state's brief, which was filed on April 1st of this year, and I'll just ask the court to take judicial notice of that brief, which is part of the record in this case. But to just sum up, the manner means the how of committing murder or assault are not elements of those crimes. And when we allege an unknown manner and means, we've done more than is required by law. The law doesn't even require us to put that in the indictment. Those are not elements of the offense. We're not required to prove them. The state's indictment tracks the statutory language for each offense, and it gives adequate notice of each offense charge. We've alleged intent, and we've alleged result. We don't have the benefit of a body at this point for a medical examiner to look at and give us a precise cause of death, but that does not prohibit prosecution of this case. I want to take a moment to address the specific points the defendant makes in his brief that was filed on Sunday. And first I want to note that the defense seems to have waived any argument with respect to paragraph A of the murder charge and the other charges in this case. It looks like at this point we're only arguing about paragraph B, which is the act clearly dangerous to human life part of the murder charge. So in his brief...
Was that accurate?
That is correct, Judge. I can respect that under paragraph B-A, under the right circumstances, the state can proceed.
Okay.
So Judge, in his brief, he gives a general statement that tracking the statutory language isn't always sufficient. But what's not clear in the brief, in my opinion, is that this statement only applies in certain situations. And it was up there, actually, in the language that he had, that the situations where that applies are when you have a conduct-oriented offense, which murder is not, and also when there are multiple different ways of committing that offense that are outlined in the statute. That's where that applies. And the case law says that very clearly in the case that he cited. One example that I can give the court is sexual assault. So in sexual assault, which is a conduct-oriented offense, it's about what the defendant did, not the result of the offense, as in murder. And if you look at the sexual assault statute, it says the defendant did intentionally or knowingly, and then it has A, B, C, D, different ways of committing that offense. And that is the sort of thing that what Mr. Gilmore cited is referring to, where you have both a conduct-oriented offense and statutorily defined alternate ways of committing that offense. That is when we have to plead specifically which one of those we're going to prove. That's what that language is talking about. So it doesn't apply to this case. Sexual assault, again, conduct-oriented. The gravamen of the crime is the act committed by the defendant. Murder, the gravamen is the result. It's the death that is caused. So that's the type of statute that requires that additional specificity in the pleadings. And we do, in sexual assault indictments, we do have that specific, like, if it was committed in this way. The statute in this case is not like that. There are no multiple ways listed. That act clearly dangerous to human life is just an element. There's no alternate ways listed in the statute to commit an act clearly dangerous to human life. What the case law that Mr. Gilmore cited doesn't say that every term that's undefined in the statute has to be pled specifically. It's just talking about those specific situations. So it just doesn't apply to this case. So there's really two reasons. It's not conduct-based, and there aren't options listed in the statute. So that argument really does not apply. And when it comes down to a defendant's argument, he claims it's about notice, but it's really about sufficiency of the evidence. What he is saying, I believe, is that we have that element, okay, it's an additional element in paragraph B of an act clearly dangerous to human life, and he's asking, well, what evidence do we have of that? And that is a sufficiency argument. It's not appropriate for a motion to quash. That's a trial issue, so it's premature to be addressing that now. And that element, the same as the merited means judge, it's too early to make that decision. So I'm asking you, Judge, for those reasons to deny his motion to quash, and for the reasons outlined in the state's brief as well.
And to you, Counselor, what about the idea that the state can only give you notice of what they know? And in this case, apparently, I'm assuming that through your representations, there is no body of complainant in this alleged offense. What do you say that the idea that the state can only give you notice of what they know?
Sure, and so take that to its logical conclusions. What other offenses could they indict Mr. Simpson for that they think they know about and they hope they produce evidence of at trial? I mean, what offenses could they indict anyone for that they don't know about now and aren't telling me about, especially in an indictment, but they sure hope to shore that up by the time we get in front of a jury? Ultimately, Judge.
Well, when you say shore up, let's say, and I know this is an alleged offense, but let's say at some point the body of this individual, this complainant, is found, then they would have to give you more notice, correct? I mean, when you say shore up, is that what you're talking about?
Well, so in a hypothetical situation where something like that occurred, I would expect the state to either amend or re-indict. Right?
So would I. So
there would now be new facts, and there would be a medical examiner's report that would allege cause and manner of death as well.
But I'm trying to figure out what you meant by when you said that they can shore up their case as they go. What do you mean by that?
Well, I mean, the state will, I'm sure, agree with me that discovery is not complete in this case. They're still waiting on at least 6 reports for the Texas Rangers that I'm aware of. And so the state is hoping that additional better evidence will appear in those reports. As of right now, I don't want to get into the sufficiency because it's not an issue here.
Well, then that's the next question. What's your response to the state's argument that this is really a sufficiency of the evidence argument and it's not right now?
Well, I mean, it's just not. So when the state was talking about the sexual assault statute, right, it listed all the different statutory ways of committing the offense. Well, that's exactly what we're dealing with here. 1902B1 is one way the person can commit murder. 1902B2 is another way, and then 1902B3 is felony murder. Then there's capital murder. There are other statutory ways of committing murder, right? And I've already agreed that under the right circumstances, the state could proceed in a manner and means unknown 1902B1 murder. I mean, just from my research, I've seen that it's appropriate to do. But 1902B2 has different pleading requirements.
But where do you get that? From the concurring
state?
I'm sorry, from the concurring opinion in Lugo?
No, from DePaul versus State, which says it
From the
explicitly.
what, I'm sorry?
DePaul, D-E-P-A-U-W.
And I read a lot of these cases, but tell me what that one says.
Sure, and that was in the PowerPoint, which I can supplement with a hard copy of. It's-
Summarize for me, please.
It's 658 Southwest 2nd, 628 at Penn site 633, out of Amarillo in 1983. Petition was refused, and that case, as it says explicitly. On the other hand, 1902B2 imposes a requirement upon the state, which section 1902B1 does not, namely that the state must allege and prove that the accused committed an act which is clearly dangerous to human life. Therefore, we believe the cases cited by appellee, which hold that an indictment is valid even though the means of the murder are not alleged in an indictment, are an opposite to 1902B2 case. So it's saying that you can do it in a 1902B1 type murder. That the person knowingly and intentionally killed another person by manner or means unknown to the grand jury. All of the opinions I've read say that they can do it that way. But DePaul says explicitly, and I've omitted the citations from the PowerPoint slide, but it cites to other cases for similar proposition, that for the purposes of 1902B2, they're going to allege an act clearly dangerous to human life. They've got to give me some kind of notice of what that act is. More to the point, how did the grand jury know that it was an act clearly dangerous to human life if they didn't know what it was? Because there are conceivable acts which could result in a person's death, which weren't clearly dangerous to human life. And in order for me to test that at trial, I would need to know ahead of time what act the state is alleging he committed. And so ruling in defense favor on this particular issue, Judge, obviously doesn't foreclose the state from proceeding under 1902B1. They still get to prosecute a murder if they so choose. It just means that if you're going to do it under B2, you got to tell them more. And if you can't tell them more, don't indict it that way.
Okay, State, how do you respond to that last point on that case that says that's too far?
Judge, give me a brief moment.
I'll give you a brief answer. Go ahead.
And Judge, I'll just add real quickly that if they do discover some act in the future, I expect they will amend or re-indict.
And Judge, just to respond to DePaul, again, that analysis is a sufficiency analysis in DePaul. And it involves essentially looking back at the statute and determining if there is enough evidence to support an act clearly dangerous to human life. And that is an element that we're going to have to prove in trial. And that, again, is a sufficiency element, but it doesn't fix the issue that defense has of really not having a case that says that we're required to give that notice of more specificity than just saying an act clearly dangerous to human life.
In DePaul, the case is cited, you're saying there was a sufficiency in the argument case?
That's
I'm sorry, sufficiency of the evidence?
I can give the court a copy of the case, which the state I know has already read. It's reviewing the court's ruling on a motion to quash the indictment starting at Penn site 633. benefit on, it's the second,
I can't hear you, I'm sorry.
just for the benefit of the record, second full paragraph on what is Bates number, page 5. Appellant argues in his first point of error that the trial court erred in overruling his motion to quash the indictment. Because the indictment language was both legally and factually, this is back when, before Brooks, when they made that distinction.
Is
Legally
your
and
mic on,
factually.
sir? Sir, I'm sorry to interrupt you. Is your mic on? Is the green light on?
Yeah.
Okay. I need you to pull it closer. I'm just.
Sure.
Thank you.
Legally and factually insufficient to allege an essential element under the offense of murder. And the state's already conceded that the act itself, an act clearly dangerous to human life, is an essential element.
Judge, when you're ready, you have a response.
Go ahead.
It's clear, in the paragraph that Mr. Gilmore cited, that this is a sufficiency review. That was the point of error that was raised in this case. And when we get to the point where they're discussing this, they say very specifically that the state's not required to plead their evidence in the indictment. What they do is they look at, in this case, there was an act alleged, and it was pled more specifically, and they look at whether or not that's sufficient. It doesn't follow from that we have to plead that, if that makes sense. It's a sufficiency review, and in addition to that, Judge, this is an Amarillo case from 1983, so it's not technically controlling for what that's worth.
Correct.
But I don't think it speaks to the point Mr. Gilmore's trying to make either.
Okay, and again, to you, counsel, Lugo, the authority claim that you're citing is a concurring opinion that the majority in that case rejected, correct?
They rejected his analysis with respect to the requisite mental state for this offense.
Okay, now, anything else on the other side?
Not from the state judge.
All right, so first of all, since you've conceded, as you stated earlier, your motion to quash the indictment as to count 1, paragraph A, is denied, and the same thing with count 2 and count 3. Now, as regards count 1, paragraph B, the state had asked for more time to brief this issue. Do you still wish to have more time to brief this issue?
Judge, if you would allow it, we think we can provide the court with more case law on point.
Okay, so since that's the main issue in contention right now, I'm going to go ahead and hold my ruling in abeyance and give the state some time to respond. And as soon as I have their response to your last reply, I'll rule on that. So I'll hold my ruling in abeyance for now as to count 1, paragraph B. All right?
May I ask how much time the state has to provide a response?
Well, how much time do you need?
A week, Judge?
Okay, 1 week. So give me a date. What's today, Tuesday?
Yeah,
Next Tuesday, whatever that date is, okay?
the 29th.
Okay, so we set for April 29th of 2025 at 9 a.m. just for that ruling, okay? Anything else?
Nothing from the state judge.
I think that's interesting.
Okay, that closes the record.